Hello, so this is the summary of the content of Article 10. So first of all, Article 10 is what we call a qualified right. This means that any interference with your rights by the state has to be justified by the state. It has to be for a lawful reason, and we'll come on to that in a minute. It has to be necessary in a democracy, and it has to be proportionate. Do remember that member states have a margin of appreciation. That was the case of Otto. So they can interpret the Article 10 slightly differently. It varies from state to state. So when can there be an interference in your rights? Well, first of all, if it's for something like national security, if it's for the protection of morals, if it's for the prevention and crime and disorder. But remember, any interference has got to be justified and proportionate. So first of all, the first right under Article 10, freedom to hold opinions. This is an absolute right. You cannot restrict this. It would be very difficult unless you tried to brainwash somebody. So you have the freedom to hold opinions. Now, the second right that you have is the freedom to impart information and ideas. The case of Handyside said that you can shock, offend, and disturb. The other thing that I would mention under this part is that the press don't have to disclose their sources. That's the case of Goodwin or the Financial Times. Often there is an issue with the press. Any interference has to be justified, and that's A versus B. Hate speech, we know, is not allowed, and that is Geraudi. Now, when deciding whether Article 10, the right to a private life, is more important than Article 8, the right to a private life, is more important than Article 10, then Axel Springer tried to help. So the court said that there's criteria when deciding whether 8 takes precedence over 10, and it's essentially looking at how the information was obtained, what is the consequence of the publication, what is the content, what is the form of the publication. Does it lead to a debate of public interest? Is it something that is in the public interest? So the public are entitled to know this. Who is the person concerned? What is the subject matter of the report? So that should hopefully help. The other thing to bear in mind in terms of freedom of expression is artistic expression. So again, there is a big difference in different cultures. The Otto Preminger Institute was a film that offended Catholics in Austria, and the authorities banned and confiscated this film. The Institute said, well, Article 10 has been breached. But the European Court disagreed. So in other words, the state was right to ban it. Remember things like stand-up comedy class as artistic expression. If you deny the Holocaust, hate speech, that is a justified restriction. So in Geraudi, he wrote a book and he denied the Holocaust. So the state was right to interfere and ban the book. The third element is freedom to receive information and ideas. So you can gather information. The media can inform you, and you should be able to read things that are a matter of a public interest. The government doesn't always have to inform you of certain things. And that was the case of Guerra, where people were living near a chemical factory. So there was an issue there, but the government, it was fine for them to not inform people about this. Okay, the other thing just to bear in mind, Article 10 and the internet, there's a Hungarian case, so you can just call it Hungary, about hyperlinks, and they were looking at, if you put an interview on YouTube that has a hyperlink with something that was later held to be defamatory, is that newspaper responsible? And they said it's okay, they can do that, and the court's decision was a violation of the company's Article 10 rights. So there's a danger that press freedom would be suppressed if you don't allow the press to function freely. So hopefully that summarises Article 10 for you. I'm going to talk about domestic legislation and evaluation in future videos.